90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. We're going to offer tips today on what some of your resources may be if you are fired, and if employers can prevent litigation if they have to fire someone. Our special guest is Tom Spiggel. He's an attorney with the Spiggel Law Firm in Alexandria, Virginia, and he also handles clients in the D.C. and Maryland areas. And the issues he deals with and the advice he offers are going to pertain in general to people all over the country. And he's also the author of Fired, Afraid, or Afraid You Might Be. Tom, welcome to Law You Should Know.
Ken, thanks so much for having me on.
I know you've been following the litigation that's mentioned, talking about Elon Musk and lawsuits over payouts that he may have promised at one time. What are some of the issues there, and how did it relate to workers everywhere?
Yeah, so this was involving his purchase of Twitter and terminating, thousands of employees, and including some that were higher level executives, and then the company refusing to pay out severance, as was dictated by a severance plan that Twitter had for all employees. And then they've sued him to try to enforce that provision. I think they have a pretty strong case. If you were promised certain benefits, and this doesn't apply to everyone. In fact, most people don't have an arrangement like this, but in some big tech companies you do. If you are offered some severance or actually any benefits, and a company fires you for the purpose of not paying those benefits, that's illegal, and that's the subject of this lawsuit.
So the new owner of the company may be liable for the benefits probably promised by the old employer? Yeah,
that's exactly right. They would be bound by that previous plan. I mean, the new owner can change the plan, going forward, but it can't retroactively change the plan and say, we had promised you these severance benefits, and now we're not going to pay them out.
Could it be arranged so the old company fires you before they shut down, and the new owner says you can apply for a job?
Well, that's essentially what he tried to do here, at least as alleged by some of the senior execs, is that he pushed through the close of the deal early and then fired them the same day, solely to prevent the company from having to pay out these severance payouts, which were pretty substantial. I mean, in the hundreds of millions. And the plaintiff, it's still the case is still pending, so we'll see how it comes out. But the plaintiffs are arguing that that kind of bait and switch was illegal under the plan they had agreed to with Twitter. And I think they probably had the winning argument.
And that would probably be true anywhere in the country.
Yes, that's true anywhere in the country. If you work for Twitter, but if you work for a company and there's what's called a defined benefit plan, and you were promised, certain benefits, whether they're health care or severance, you name it, stock options, the company can't just pull the rug out from under you by saying, oh, you know what, we're going to fire you the day before these vest. And that would apply to any employee that's subject to that plan nationwide.
And whether you've been at the company for 40 years or 2 years or 5 months, it's important you do save those documents to prove
absolutely.
Whatever was offered to you, whatever you relied on, including whatever documents you got down the road.
Yes, no question.
Employees generally, how can they use information that's in your book, Fired or Afraid You Might Be, to fight adverse firing, to avoid being in the situation that Elon Musk employees are in?
Yeah, absolutely. My book is really sort of a step-by-step process of explaining how an experienced attorney would evaluate your case. and how you can position yourself to best succeed on your terms, because it's really, right, it's your case, it's your objectives, and something that's important to you may not be as important to someone else. And you need to be clear about that at the outset. And I talk about, how do you decide what your case is worth? How do you determine if a law has been violated? And then what the litigation process looks like, and how you can, apply the most leverage that you can to achieve whatever goals that you set out at the beginning of the litigation.
And along with that, what are some do's and don'ts if you're afraid of being fired or you're actually fired?
I think it's always best to go consult an attorney sooner rather than later. One mistake I see people make, particularly if they are at the company and still employed, if something is happening to them there and they believe they're being discriminated against or being harassed, they don't say anything, and then they end up getting fired. And you still have a claim at that point, but if you're at the company and there's been some wrongdoing and you report it, then you can have additional legal protection called anti-retaliation, which is under many federal laws. And it's a very strong claim. In fact, you can lose the underlying discrimination claim and still win a retaliation case. But you have to put that in writing, usually in writing, to the employer to put them on notice that you think you're being subject to illegal activity. And I see a lot of people who, understandably, they're worried or they're afraid what's going to happen to them. And so they don't say anything. And then they get fired anyway. And they still have a claim, but then they've lost that
and technically, and if you make that claim, you cannot be retaliated against for making that claim.
Exactly. Companies still will try to do it, but it is illegal to retaliate against you for making the claim. Even if you are wrong about it, as long as you have a good faith belief, then you're protected, at least under most federal anti-discrimination laws.
So even if your claim wasn't strong enough, if you are harassed or retaliated because you made the potential claim, that might give you additional protection.
Exactly right. So if your example is perfect. If you were to claim hostile work environment, that's a pretty, can be tricky as a legal matter to prove that. So you could have a court say, well, we think what happened to you didn't rise to the level of a legal hostile work environment, but you did complain about this to HR and then they fired you. So you do have a retaliation claim.
And that hostile claim, that might have a lower bar if you're fired.
The retaliation claim tend to be easier to prove because often it's a timeline, right? Like, hey, I sent the email or the letter on this date raising these issues of mistreatment, and then a month later I was fired. And those are strong cases because, just as a matter of common sense, well, you sent this in and then you were fired. Like, what's the reason? Well, probably because you sent this email in.
And so is it also useful before they make some complaint at work or make some complaint to a governmental agency, if they consult you so they have the proper wording of that complaint and the proper timing of that complaint?
Yeah, I think it's, and this is one thing I talk about in the book. You can go consult with a lawyer without hiring him or her to handle your whole case. Lawyers typically, particularly in what I do in representing employees, we'll do an hour consult, and then within an hour, a good experienced, employee side lawyer is going to be able to give you a good sort of roadmap. They won't know everything about your case, but they can help you, as you say, construct the email in a proper way and word it in a proper way so you're sure to engage in what's called under the law protected activity, because just raising a complaint by itself may not give you that retaliation protection. You have to say something that puts the company on notice that you think you're being mistreated based on what we call protected category, your race, your gender, your age, your disability. So I think it makes good sense to have a lawyer look that over.
And complaining in the wrong way may not help your case.
Right, absolutely. And complaining the wrong way could get you fired in a legal way.
Right.
So what you don't want.
And it's better off to, get the advice from an attorney so you can fashion your complaint. You can make it in the right way at the right time and to the right people.
Yeah, exactly. And if you're inclined to hire someone, hire an attorney to represent you, the attorney doesn't necessarily have to, go to the company on your behalf. I mean, he or she can, but you may want them just in the background just to advise you not only on the issues that you just raised, which are important, but once you send that email, like things are not going to be easy for you at work, and HR may want to interview, and there may be other things that come up, and it's helpful to have a lawyer. You can just pick up the phone and say, hey, HR just called me down for a meeting. Like, what do I do? Or this has happened. My boss is doing this. What do I do? It can be tricky if you're still there.
Would it be a good option to have a lawyer like you present at that interview?
Well, yes. If it is allowed, it depends on the nature of the interview. Companies aren't required to let a lawyer come to an HR interview unless the company's going to bring their lawyer. So if the company brings their lawyer and you've retained an attorney, then under professional responsibility rules, that company lawyer can't talk to you about the matter that you're being represented without your attorney there. Okay. So in that situation, you definitely want your lawyer there.
And if you're in a union, do you have some right to have a union rep there with you at these meetings?
Exactly right. Yes. Under most collective bargaining agreements, if there's going to be, proposed discipline, then you have a right to have a union rep there. So if they try to have a meeting with you without that rep, you need to make it clear, like, hey, I want my union representative with me, is allowed for under the collective bargaining agreement.
And is it true for most unions, or it's a function of state law, how much representation the union might provide for you?
Yeah, it varies from union to union. Most of them will provide, some kind of, an agent or a representative to help you in the meeting. Sometimes they will, they'll provide counsel. They'll provide a lawyer. That tends to be more rare, but it does happen. But it varies, by union by union, depending on what kind of agreement they've struck with the company and with their representatives.
And let's say that you think management is going after you. They're giving you negative reviews. They're not giving you good options. They're maybe reflected of your training or your seniority. Should you voice them? Should you consult with a lawyer about what your rights or options might be?
I would. I would always, if I could, talk to a lawyer just to determine if what's happening to you is illegal. And that's something I talk about in the books, because sometimes it's not intuitive. It's not obvious. There are many things that can be wrongful that happen to you at work that aren't necessarily illegal. And unless you do this work, it can be hard to tell. So it helps sometimes to talk to a lawyer and say, hey, this is what is happening to me. Is this illegal conduct? Because, courts are pretty clear that companies are entitled to be poorly run, and managers are entitled to be poor managers, but that's not in and of itself illegal. But where that line is can be difficult if you don't have training.
I would just like to remind our listeners, we're talking with attorney Tom Spiggel. He's the head of the Spiggel Law Firm in Alexandria, Virginia. He also handles matters in the District of Columbia and Maryland, and the information he is providing might be applicable to other states and other employment situations. And he's also the author of Fired, Afraid You Might Be, which, as you've mentioned, provides information to people who are fired or afraid they might be. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. Tom, can you give us the website for your firm, and where presumably you have other information about the work you do, helpful information for employees, and information about your book?
Yeah, absolutely. You can go to our website, which is Spiggel Law, Spiggle law.com. We have a lot of information on our website. You can go to our YouTube channel. We're on all the social media, TikTok, LinkedIn, and we're always sharing as much information as we can. You can find the book on the website. You can also find it on Amazon. I've also I wrote a book before this one called You're Pregnant, You're Fired, which you can also find on the website and on Amazon.
And on pregnancy, what are some of the recurring issues, and what rights do employees have during the pregnancy, and maybe for wellness or as parents?
Sure. Well, if you are pregnant in the workplace and you are part of a protected category, and an employer can't, discipline you, fire you, take action against you just because you are pregnant. And, unfortunately, we see this happen, even today quite a bit, where, a woman's doing a great job at work, knocking the top out of it. She gets pregnant, and then all of a sudden she starts getting negative performance reviews, or otherwise kind of pushed out of the company. And that's illegal under the Pregnancy Discrimination Act. As to wellness, there are a number of laws that are relatively new that provide protection to women at work. One is called the Pregnant Workers Fairness Act, and it allows the woman to ask for reasonable accommodations. So if you need a place, more frequent bathroom breaks, you need, a different kind of chair, you need something to allow you to be able to continue to do your job. That employer, as long as it's not an undue burden to the employer, which is a very high bar to meet, the employer has to try to help you achieve that and engage in kind of an interactive process with you. And that law is pretty new. There's also what's called the Pump Act, which protects women and their right to express milk at work. And they have to be given, a private space to be able to express milk at work. That's not a bathroom, because that's what we saw before. Is a lot of companies like, well, you're welcome to use the bathroom. As one can imagine, that's not a particularly comfortable place for a woman to do that. So it provides rights to women in that situation. And then, as true for men and women, after once the child is born, if the company is over 50 employees and you've been with the company over a year, then you probably have family medical leave rights, both men and women, which allow you to take time off from work and have your job protected. And then even after that, it is illegal for an employer to treat you differently, whether you're a man or a woman, because you have kids at home. They don't have to accommodate you in the sense that, you need to take off to, go pick up your kid from daycare. Most employers will do that, but they're not required to do that. But they can't penalize you. They can't, for instance, say, well, women with kids at home, they just don't work as hard, so we're just not going to give her the promotion. Or men with kids at home, they're always sick, and so, we want to get rid of this guy because we know he's not going to perform. Like, those sorts of things would be illegal.
And let's talk about the family medical leave. What are the situations might it come in, and does it apply to stress or mental health? And does it apply to stress or mental health that's not job related, or a combination of factors?
It could. You have to be eligible for the act. Like I said, the company has to have all these, rules involved with FMLA. The company has to have at least 50 employees within a 75-mile radius. So they could have 25 in one area, 10 miles down the road, 25 down the other, and then it's covered. And then you have to work there mostly full-time for a year. And then if you're covered, you can take time off from work if you have what the law calls a serious medical condition. Childbirth is definitely one of them. But if let's say you brought up the issue of mental health, it doesn't necessarily even have to be work-related, but you do have to be, usually, to qualify as a serious medical condition, under the continuous care of a physician. So let's say you have, severe PTSD and you're under the care of a psychiatrist, and the psychiatrist says, you need to take some time off of work. That would very likely qualify as a serious medical condition that you can take up to 12 weeks, unfortunately unpaid, but up to 12 weeks off without losing your job or being otherwise penalized. Would
your benefits continue, or you'd have to pay for them?
Yeah, benefits will continue. So it's just as, it's almost as if the company just kind of puts the pause button on your benefits, your salary, continues. And then 12 months later, you come back and, you're right back where you were with all the same benefits, all the same salary. And it would be illegal FMLA interference, which can be very costly for the company, for them to deny you that right, or fire you because you asked for it, or interfere with your leave. All those things are you can file a federal lawsuit for.
And let's say, does an employer have the obligation to provide a less stress environment or protect you from additional stress, or the job is what it is?
Yeah, that would be under a different law. So not under the FMLA. An employer is not required to what we call accommodate you. However, under the Americans with Disabilities Act, which actually covers a broad swath of people, like it's not just somebody necessarily like in a wheelchair who's like, got, significant disability. It can be somebody with a mental health issue, even if it's temporary. Again, let's say it's a woman who just had a baby and it's postpartum depression, or it's what they call generalized anxiety disorder. If you have those conditions, then you're considered disabled under the Act. And if you asked your employer for workplace changes, then the employer has to, by law, at least engage with you to try to make those changes.
Would that apply to like a teacher or a lawyer and change the work they're doing because they're stressed out, or it's too much stress for them and with their current state of responsibilities? Yeah.
So you would be entitled to some accommodations, but you have to be able to perform the essential functions of your job with that accommodation. So, if we're talking something temporary, you need a change for a couple of weeks, to help deal with the stress, then you're more likely to be successful under the Americans with Disabilities Act. If you need you need the job to change, then that may mean you can't perform the essential functions of the job. If you're in a stressful job and that's just part of the deal, you can't force the company to change the job wholesale because you're having a negative reaction to it. Again, if you need, if you need to take time off to see a doctor, if you need a slightly different work environment, all those things can be achieved, but you can't. The company's not required to completely change the job for you. You have to be able to perform the essential functions.
Okay. I'd just like to remind our listeners, we're covering a lot of interesting issues as we talk about issues on the job, or what if you're fired and afraid you might be. That's the title of his book. And we're talking with Tom Spiggel. He's an attorney and the head of the Spiggel Law Firm in Alexandria, Virginia. But he also handles cases in District of Columbia and Maryland. And many of the concepts he's discussing apply anywhere in the country. And whatever you're hearing is designed to be legal information only, and you must get legal advice from an attorney in your area who've retained and is qualified to give you advice. You're listening to Law You Should Know on 90.3 WHPC, the voice of Knox Community College in Garden City, New York. And if you missed any portion of the program or you want to tell someone else about it, just go to the website nccradio.org. What are some other issues that you think will become more active in the future concerning employee discharge or employee wellness?
AI is the big one on the scene right now, and how that's going to, impact the workforce, and the use of AI and hiring decisions has become a hot button issue. The Equal Employment Opportunity Commission, which is the big federal agency that enforces a lot of federal workplace laws, just recently issued some guidance on that. Work from remote work continues to be a hot issue, both in terms of management and also the legal implications for remote work. That's a hot topic. And related to that, employee monitoring by companies and, the data that they collect as part of that process are all growing, hot button issues.
And employees should be aware that their computer keyboard may be monitored. Perhaps maybe they're being videotaped in the office or the warehouse.
Yeah, absolutely. I mean, there are all kinds of keystroke is a big one. I've even heard of companies will use special chairs that can tell whether you're sitting in them or not. And absolutely, cameras. There's all kinds of sophisticated, with AI that's got even more sophisticated with that's supposed to be able to tell, not only with your keystrokes, the nature of your work and what you're doing. I mean, it's some powerful.
And soon AI may be evaluating you or even firing you.
Yeah, but HR, I think it's going to continue to play a bigger and bigger role. And, what we've seen so far with AI is it offers great promise, but it's not perfect. And in fact, it's essentially trained by humans, even if it's only just a matter of these large language models going out and collecting all this information off the internet. This information was all created by people, and people have biases. And we're seeing that coming through in AI as well. So that's going to be a big issue.
And just going back to something you spoke about earlier, if someone feels they're in a precarious situation at work, it's good to contact someone like you before there's a firing, before there's discipline, before there's a review, just see what the rights and options might be.
Yeah, absolutely. I think that's best practices. But, if you don't do that, or you didn't see it coming, you get fired, of course, still then go talk to an attorney, because there can be some very short deadlines in employment law, particularly for federal discrimination claims. You've got either 180 days or 300 days, depending on the state, to file a charge with the EEOC. If you go one day past that, you lose your right to sue, no matter how strong your case is.
And if you are given a severance agreement and maybe some money involved, you do have a right to have an attorney go over it with you.
You don't have a right to have an attorney go over with it. Many companies will actually encourage you to, and regardless, I think it makes good practice to have an attorney review it, because they're full of legalese, and there can be some traps that you may not be aware of.
And sometimes the attorney can negotiate for you before you've signed it. Once you've signed it, you may have signed many rights away. So before you sign it, an attorney might be able to negotiate a better deal or better options for you.
Exactly right. Yeah, so exactly right. The attorney can get in there and talk with the employer and negotiate the money up, maybe take out some of the language that's problematic. For instance, sometimes companies will put a non-compete provision in there, which can, lock you up from working for somebody, a similar employer, and you want to take those out. Some of them have really, restrictive, what we call non-disparagement agreements that really limit what you can say about what happened, and those you got to be careful of.
And usually those don't cover the ability to file a complaint against a governmental agency.
That's true. Yes, you can still file a complaint, with the EEOC. They can't prevent you from doing that. However, they can legally prevent you from getting monetary damages from that. So you can still file, but if there's a payout, you're not going to get a payout.
Okay, so
that is legal.
And just give us your website again, and just mention again what information is available on your website. Yeah,
it's Spiggel, S as in Sam, P as in Paul, IGGLE, SpiggelLaw.com. And you can find all our resources there. We have a podcast. We have a YouTube channel. We're on TikTok. We're on LinkedIn. And we're always pumping out a lot of information. You can find that all on our website.
And just remember, if you've missed any part of the program or you want to tell someone else about it, it's available at nccradio.org. I'd like to thank our guest, Attorney Tom Spiggel, for being our guest on Law You Should Know. And please join us next week at this same time on 90.3 WHPC, the voice of Nassau Community College, for another program on Law You Should Know.